In Ontario, we have built a free and democratic society, founded on the principles that government must be open and accountable, and the rights of individuals must be respected and protected. Key to these principles is an informed public. To strengthen the public's access to information and right to privacy, the Ontario government introduced in July 1989 a bill titled the Municipal Freedom of Information and Protection of Privacy Act. The new legislation will come into effect January 1st, 1991. It will extend to more than 2,500 municipalities and local boards the access and privacy principles already enshrined in legislation covering provincial ministries and agencies. These principles provide a balance between public access to information on the one hand and an institution's legitimate need for confidentiality and the protection of personal privacy on the other. The Act is based on 4 general principles. First, the public has a right of access to information held by institutions covered by the Act. Second, necessary exemptions from the right of access should be limited and specific. Third, decisions on disclosure of information can be appealed to the Information and Privacy Commissioner for independent review. And fourth, personal information should be protected to ensure an individual's right to privacy and access to his or her own personal information. Let's examine each of the 4 principles. The public has a right of access to records and information held by municipalities and local boards. Any person can make a request for access to records. Requests must be in writing, providing clear detail about the kind of information required. The time limit to respond is usually 30 days. Fees covering certain costs of processing requests will be established by regulation. It is important to understand, however, that with some exceptions to protect personal privacy, existing access to information will continue as before. Access requests under the Act should be needed only where information is not available through normal channels. The Act should enhance existing access, not restrict it or make it more cumbersome. Even though there is a general right to access, there are exemptions to this right. Access to a record or part of a record may be denied. The exemptions, however, are limited and specific, including records of closed meetings, law enforcement matters, third-party commercial information, the protection of personal privacy, and certain others. Even where an exemption is applied, however, municipalities and local boards are required to make as much information as possible available. This is done by removing only the exempt material from the record and releasing the remainder. With the exception of personal information, exemptions should not be used to deny access to information which was available before the legislation comes into force. Remember, the spirit of the legislation is that, with clearly defined safeguards built in, more, not less information should be available to the public. Decisions on disclosure should be reviewed independently. If a person who has made a request does not agree with the institution's decision on access, an appeal can be made to the Information and Privacy Commissioner. The Commissioner, as an independent officer of the legislature, will investigate the decision and rule according to the provisions of the Act. Personal information should be protected to ensure an individual's right of privacy and right of access to his or her own personal information. The Act provides a balance between access and privacy. Although it establishes a right of access to records, the legislation also makes a very strong statement on the need for privacy protection. These privacy provisions amount to a code of fair information practices. Essentially, the Act provides a consistent set of rules governing the collection, use, and disclosure of personal information. In general, only personal information that is needed for lawfully authorized activities should be collected. With some exceptions, personal information should be collected directly from the individual to whom it relates. Again, with some exceptions, personal information should only be used or disclosed for the purpose for which it was collected. It is also important to ensure that personal information is maintained and disposed of in a secure manner to protect personal privacy. While the Act makes a very strong statement on the protection of privacy, it also establishes the right of access to an individual's own personal information. Any person may access their own personal information, with a few exceptions, and request a correction if they believe that it is inaccurate. If refused, a statement of disagreement can be placed on file. Personal privacy is a concern in today's society. We live in the information age. The Municipal Freedom of Information and Protection of Privacy Act establishes a framework for privacy protection and provides municipalities and local boards with clear and consistent rules for responding to access requests. The Municipal Freedom of Information and Protection of Privacy Act, a framework for decision-making, balancing access with privacy protection, in keeping with our key democratic principles. The Municipal Freedom of Information and Protection of Privacy Act, key to the community. Municipal Freedom of Information and Protection of Privacy Act takes effect January 1st, 1991. Under the Act, each municipality and local board will be responsible for responding to access requests from the public, usually within 30 days. This involves locating the record, reviewing it for information that may be exempt from access, preparing the record for disclosure by removing or severing the exempt material, responding to the requester, and administering fees. Municipalities and local boards will also be responsible for protecting individual privacy by complying with the privacy protection provisions of the Act governing the collection, use, and disclosure of personal information. To get ready for January 1st, 1991, each municipality and local board will have to establish internal processes and procedures suited to its own situation, size, and organization. The first step might be to identify and designate an access and privacy coordinator. For many municipalities and local boards, this will be a part-time responsibility for an employee with related duties. The coordinator plays a key role in implementation planning and establishing decision-making and administrative processes. The role of coordinator should be publicized and understood within your organization. If the size or structure of your organization requires it, a committee could be established to help the coordinator. Such a committee might consist of department representatives, senior management, and the coordinator. Second, an implementation plan should be developed. The plan should identify, assign responsibility for, and set target dates for implementation activities. The plan should be reviewed regularly to make sure that deadlines are being met. Third, your organization's records and information management practices should be reviewed. This will benefit the whole organization and help comply with requests quickly. Is there an up-to-date inventory of records and descriptions of personal information collections? Is there a file plan which categorizes documents by subject heading for easy retrieval? Does your organization have schedules or bylaws for the retention and disposal of records? Is there an inventory of all forms used to collect personal information? The fourth step is to review all personal information management practices throughout the entire organization for compliance with the privacy provisions of the legislation. Identify and describe what personal information is collected. How is it collected and used? How is it disclosed? And how long is it retained? Fifth, detailed procedures for tracking and responding to access requests should be developed before the Act is in force. This includes procedures for date stamping receipt of requests, setting up files for each request, routing requests through the organization, meeting deadlines, communicating with requesters and affected third parties. Finally, training and awareness sessions for staff. As many staff as possible should be made aware of the legislation and its general requirements. For staff directly involved in responding to access requests, in-depth training will be required. To recap, to get ready, you should identify a coordinator, develop an implementation plan, review information management practices, especially how personal information is managed, develop procedures for tracking responses to access requests, and conduct training and awareness sessions for staff. The Municipal Freedom of Information and Protection of Privacy Act will complement your existing information practices. It provides a framework for balancing access to information and the protection of personal privacy. The legislation builds on the principles of openness and accountability and the rights of individuals. The Municipal Freedom of Information and Protection of Privacy Act can really be the key to the community.
Hello, I'm Catherine Swing.
And I'm Michael Beattie.
And today we look at the issue of access to information and protection of privacy in Ontario.
Information. More words and numbers have been recorded in the past 30 years than in the rest of history. It's an information explosion. But what information is being collected? Where is it stored? What about personal information? And what about my right to privacy?
In recent years, the public has begun to expect more access to information held by our various levels of government.
Government information, general information and personal information. Access to either kind has not been easy, but things are changing.
Recently, the province of Ontario passed a new law. It's called the Freedom of Information and Protection of Privacy Act. It came into effect January 1st, 1988. The act gives everyone in the province two specific rights in relation to information held by the government.
First, the act allows people to access provincial government information, including personal records about themselves. And second, the act ensures our personal privacy is protected.
These really are sweeping new rights, and to make sure they're respected, the act has created a new officer of the legislature, the Information and Privacy Commissioner. We go now to our senior Queen's Park correspondent, Will Finley.
Will, just what kind of experience does one need to fill the role of commissioner?
Well, Michael, Sidney Linden has had a lot of previous experience with public service in the law. Before his present appointment, he was executive director of the Canadian Auto Workers Legal Services Plan. He was also public complaints commissioner and chairman of the Police Complaints Board. He is a lawyer, and he served as the first general counsel of the Canadian Civil Liberties Association. So I'd say he's pretty sensitive to public policy issues.
Will, you met with Commissioner Linden earlier. Let's go to that now.
Mr. Linden, how would you define the principal role of the Commissioner's office as created by the legislation?
I'd say the main object of the Commissioner's office is to act as an oversight or appeal agency to ensure that the government properly applies the provisions of the Act. And the second part of it is to protect people's privacy, make sure that the government takes adequate safeguards to protect the privacy of individuals.
What about the implications of the Act for the people of Ontario? What's the most important aspect?
Before the Act was passed, if people asked the government for information, the government could give it out or not as they pleased. What the Act has done, it's created a right to information. Instead of a privilege, you now have an absolute right to government information. If an exemption in the Act doesn't apply, then they must release the information. It puts an affirmative onus on the government to release information.
Unlike some officials, Michael, the position of commissioner is not a governmental or political appointment. He's employed by the legislature itself.
So he doesn't report to the government or any political party. He reports directly and only to the legislature.
That's right. This ensures his complete impartiality in the decision-making process.
Thank you, Will. Catherine?
To find out more about this unique piece of legislation, we go to Mr. John Eichmanus, Senior Policy Advisor to the Commissioner and former project manager for the Williams Commission. Mr. Eichmanus, the very name, Freedom of Information and Protection of Privacy Act, seems contradictory.
Well, you have to remember that this act was based upon the recommendations of the Williams Commission. And this commission in the late 1970s recommended that the two concepts be joined under one act. The commission had looked at various other jurisdictions around the world and had realized that in most places the two acts didn't fit neatly together. In Ontario, we have melded the two concepts under one act, and so far it seems to be working quite well.
Recently you wrote that freedom of information is the cornerstone of a democratic society. What did you mean by that?
Well, what I mean is that in democratic society, you want to encourage citizens to participate in the policy-making and deliberative-making processes of government. And the only way they can do that is by having access to all kinds of information, including government-held information. As you know, history has shown that tyranny thrives on secrecy. In Ontario, we have legislated an act which gives an individual right to have access to government-held information and thereby make a bigger contribution to the political process.
Mr. Eichmanus, we thank you.
Under the Act, any resident of Ontario can apply for information.
A person can apply for two types of information. First, general records, such as reports on government investigations, and second, personal information, such as financial or employment records.
And of course, before you can even begin to access this information, you need to know which government departments to contact. The Act helps you locate most records by requiring the government to publish two comprehensive guidebooks.
The Directory of General Records contains a description of each institution covered by the Act and the types of records they hold. The Directory of Personal Information Banks contains a complete listing of all banks of personal information held by those institutions covered by the Act.
These books are available at public libraries or provincial government offices, or you can purchase them from Publications Ontario.
Once you locate where the records are being kept, you then contact that particular ministry's Freedom of Information and Privacy Coordinator.
We talk now with Elizabeth Flavel, the coordinator at the Ministry of Community and Social Services. Ms. Flavel, supposing I've looked in the directories and found that the information I want is held by a particular ministry, yours, for example. How would I go about applying for this information?
Initially, go to the office or give a call and see if we have it. If we can provide it to you and it doesn't violate the Act, we'll give it to you.
Now, what if the information isn't available that way?
If the information isn't available because it has personal information or in some way contravenes the Act, then we'll help you put in a request. It can either be on a form or a letter. And we'll work with you to help you find out the best place to send it and to make it clear enough the person who receives it understands it.
All right, now suppose my request is turned down. What options do I have? Who is the final authority?
The final authority is the commissioner. We, in every letter we send to the person, will tell them our decision. And if they don't like it, we also put in there that they can apply to the commissioner for a review of that particular decision.
So the role of the commissioner and the government are completely different from one another.
They're different pieces of the same puzzle. Our job in the Ministry, for example, of Community and Social Services, is to ensure that we honor the requests to the best of our ability according to the Act, and that we honor the principles of privacy. The role of the Commissioner's office is to ensure we do our job right.
Ms. Flavel, thanks for your help.
So, under the new Act, anyone can challenge a government's decision to withhold information. In a moment, we'll investigate just how the appeal process works. We're looking at Ontario's new legislation called the Freedom of Information and Protection of Privacy Act. To find out how the appeal process works, we speak to the Commission's Manager of Appeals, Judith Keene. Ms. Keene, who has the right to appeal?
Well, there are three situations in which people appeal. The first is when somebody's asked for general information from the government. The second is when they've asked for their own personal information. And the third is when they've asked for a correction or a statement of disagreement to be attached to their own personal information.
And just how does the appeal process work?
Well, the appellant sends us a letter, and we open a file and assign an appeals officer. The appeals officer speaks to the appellant, takes a look at the record, speaks to the institution, checks out the circumstances which gave rise to the appeal. Often the appeals officer finds that he or she can settle the case and reach some sort of compromise available or acceptable to both the appellant and the institution. We settle a lot of cases that way. If we can't settle the case, it goes on to a formal inquiry. And in that case, there's a report that we issue, and all parties to the appeal are invited to give their opinions on the issues in the appeal to the Information and Privacy Commissioner. The Commissioner considers the views of all of the parties before making a decision.
After the inquiry, who makes the final decision as to whether the request is granted or not?
That's the Commissioner. The Commissioner has the authority to make a final and binding decision.
Ms. Keene, we thank you.
You're welcome.
Michael, having access to information about myself is a good thing. No one can really argue with that. But what's to keep other people from getting that same information? How is my privacy protected?
Well, that's a good point. And to clarify the privacy issue, Catherine, we have with us today the Director of Compliance in the Commissioner's Office, Ann Cavoukian. Ms. Cavoukian, what about personal privacy?
Well, Michael, my role at the Commissioner's Office is to ensure the protection of your privacy, the privacy of your personal information that the government has. There was an international code developed to govern the collection of information. It's called the Code of Fair Information Practices, and this basically governs the collection, the use, the disclosure, the retention, and the disposal of personal information that the government holds on us all.
Now, the Commissioner also plays a role in compliance. Can you tell us what compliance means?
In a nutshell, we want to ensure that the government complies with the provisions of our Act, and we do that through a number of various means. For example, we investigate complaints that are lodged with our office. We audit computer systems of the government to ensure that they comply with the provisions of our Act. And in addition, we function in an advisory capacity where we provide consultation to agencies who require our assistance in the development of new computer systems.
What kind of policy concerns are you dealing with right now?
Well, right now, a very timely issue is the confidentiality of medical records and health-related information. It's very important that medical records be kept very secure and the necessary precautions taken to ensure that other people do not have access to this information. A very timely issue in this regard is the issue of AIDS. We're in the process of developing an AIDS policy. It's obviously very sensitive information and for the most part should not be stored with any personal identifiers associated with it. We're working also very closely with other jurisdictions such as the federal government and other provinces to ensure that we develop a consistent approach to this topic. We don't want the public to be confused by a number of different policies.
Ms. Cavoukian, thank you very much.
Thank you.
Earlier, Will Finley and Commissioner Linden discussed the uniqueness of this legislation and what it means to the people of Ontario. We go to that now.
The thing about the Ontario Act that makes it unique is that it combines the two subjects of access to information and protection of privacy in one act. In the federal system, which you may or may not be familiar with, the two systems are quite separate. There's an Access Commission and Commissioner, and there's a Privacy Commission and Commissioner. In Ontario, they've combined it into one agency. That's a very important distinction. The other thing that's equally important is they've given the Ontario Commissioner the power to make a binding order. Usually, the Commissioner can recommend the release of information, which the government may or may not accept. But under the Ontario Act, after the Commissioner conducts his review, he makes a binding order, which is binding on all parties, including the government.
Does the public really benefit from this order-making authority?
I think the idea is it eliminates the need to resort to the courts. The hope was that it would be faster and cheaper for ordinary citizens to use the system. The other side of that is it requires the commissioner to be responsible. The orders that the commissioner makes are very much like judgments of the court. They have to be consistent and they have to be sound in law. And it also makes it tougher for the commissioner to be an advocate on behalf of a user, because he has to be more judicial in his role.
The act has been in place for some time now. Is it working?
Preliminary statistics indicate that it is working exactly as it was designed to. Over 4,500 people have asked for information in the first year. The vast majority of them received 100% of what they asked for within 30 days of making their request. Preliminary statistics also show us that approximately 1 in 12 appeal to this office, and we've been able to resolve satisfactorily the majority of those appeals, 57% in the first year. So I think it is working.
Will, it appears that the commissioner is managing to strike a balance between the new rights granted under this legislation.
That's right. Balancing both aspects of the legislation, that is the information and the privacy, will be a continuing challenge for the commissioner. Mr. Linden and his staff have addressed these issues for some time now, and from all indications, it appears the act is working.
Thank you, Will. The act protects your right to privacy and enforces your right to know. The government cannot ignore your request for information unless the act exempts it.
And if the government refuses your request for information, you can go to that department's Freedom of Information and Privacy Coordinator with a formal request under the act. A department has 30 days to respond to your written request.
If the government turns down your written request, you can appeal by contacting the Information and Privacy Commissioner.
And finally, if you can't find what you want or don't know where to look, you can call this toll-free number.
For Will Finley at the legislature, Michael Beatty, and myself, Catherine Swing, thanks for watching.
Secure and safely protected. The more valuable something is, the more carefully we need to protect it. Personal privacy is one of the most valued rights of living in our society. But we're also living in the information age. The more advanced and efficient our technology for record keeping gets, the more things we can do with the information, and the more valuable that information becomes.
Ontario's new Freedom of Information and Protection of Individual Privacy Act formally recognizes the value of personal information and is designed to protect it. The legislation does this in two important ways. First, it sets the standards for the collection, the use, and the disclosure of personal information by government ministries and agencies. And second, it gives us the right of access to our own personal information. We can even request corrections to our records should they be inaccurate.
Throughout our lives, personal information is collected from us and stored by government ministries, agencies, crown corporations, and other government bodies. This information may include our name, address, our financial status, national or ethnic origin, marital status, educational, medical, and employment history, reference letters about us, and even personal opinions. As individuals, we want our privacy securely guarded. We want to know the nature of the information collected about us, how and why it's being used, and who uses it. And we want to know that it's accurate. The new Freedom of Information and Protection of Individual Privacy Act is simply the legislation of these basic, fair expectations. Now, as managers of personal information, we're in a key position of responsibility. We have a crucial role to play in seeing that our new privacy rights are upheld. But all the Act really requires is that we handle the personal information of others as we'd expect our own to be handled. This presentation has been prepared to outline the privacy protection requirements of the Act and the procedures they entail. Above all, we have to think in a new way about the personal information that we collect, use, and disclose to others in our daily work. To begin with, there may be some changes in the sort of information we're allowed to collect and in the manner of collection. The Act allows us to collect only that personal information which is necessary to the operation of a particular program or activity. It's important to remember that this includes the verbal collection of information. For instance, the collection of personal information through a telephone interview. As a general rule, personal information must be collected directly from, or with the consent of, the person to whom it relates. There are a few exceptions to this rule, but they are limited to the specific provisions in the legislation. When information is collected about an individual, he or she must be made aware of the authority for the collection and the intended use of the information. And in case any questions or concerns arise, the individual must be provided with the title, the business address, and the telephone number of a contact person within your ministry or agency. And in most cases, thank you, this notification can simply be added to the form used to collect the information. Once personal information is collected, it's normally organized and stored in a manner that makes it easy to retrieve, whether it be in a computer database or a filing system. When the personal information is part of an organized collection and can be retrieved using a personal identifier, such as a name or a social insurance number, the Act refers to this collection as a personal information bank. Each personal information bank under the custody or control of a ministry or agency must be listed in the directory of personal information banks. The directory helps to ensure the accountability with respect to the collection, use, disclosure, and management of personal information. For each personal information bank, it provides a description of the types of information maintained, how the information is used, and to whom it may be disclosed. The Freedom of Information Coordinator in each ministry or agency ensures that the directory of personal information banks is complete and up to date. To assist the public in locating and accessing their records, the directory is available in libraries and Ontario government offices across the province.
The general rule is that personal information may be used or disclosed only for the purpose for which it was obtained, or for a consistent purpose. Now, consistent purpose means that the individual might reasonably have anticipated the use or disclosure at the time the information was collected.
For example, an employee would expect that information collected at the time of hiring might also be used by payroll to issue a paycheck. Of course, use or disclosure of personal information is also permitted where the individual consents to it. There are a number of other exceptions, but again, they're limited to the provisions specified in the legislation.
One very important thing to remember is that individuals have a right to know how their personal information is being used and to whom it's being disclosed. Most of the time, that's a simple matter, as you'll be using or disclosing information as listed in the directory. There will be some instances, however, where personal information is used or disclosed for a purpose not listed in the directory.
When this happens, a record of use or disclosure must be linked to the personal information. In effect, this attachment becomes part of the record itself and must appear when the record is accessed. The record of use should specify what information was used, for what purpose, and by whom.
In some cases, a one-time use or disclosure will become regular and ongoing. When this happens,
contact your Freedom of Information coordinator so that the new use or disclosure is included in an update of the directory. But remember, the new use must be consistent with the purpose for which the information was obtained. Maintaining an accurate record of use will also become important when an individual makes a request under the Act for a correction to his or her personal information. If a correction is made, every person who has had access to the information over the previous year must be notified, should the individual request it. Secure maintenance and handling procedures are required to ensure the confidentiality of the information in our custody. All information must be strictly protected, whether it be with a confidential computer access code or a locked file cabinet. Implementing our new right presents all of us with a challenge. But remember, if you have any questions or need help, your Freedom of Information coordinator will be on hand to assist you. The Freedom of Information and Protection of Individual Privacy Act. Let's make it work for all of us.
There's no doubt we live in an information society. It seems that almost every day a whole lot of personal and not so personal information is collected by some agency of government. Sure, it's all needed for some very important reasons, but where does it go? What does it mean to us? These are questions that deserve solid, easily accessible answers. But sometimes in the past, getting those answers wasn't easy. And there were a lot of good reasons for that, too, usually having to do with security, law enforcement, or the protection of individual privacy. But the reasons for refusing information were often obscure or contradictory, a cause of confusion and frustration, both for those asking the questions and for those who were supposed to answer them. But not anymore. Now there's Ontario's Freedom of Information and Protection of Individual Privacy Act. Ontario's Freedom of Information and Protection of Individual Privacy legislation is the culmination of years of intense study and review, both of the needs and wishes of Ontarians and of the experiences of other jurisdictions which have enacted similar legislation. Its spirit and thrust are twofold: to make the process of government as open as possible by ensuring access to information held by government, and to protect the privacy of the individual in matters of personal information collected and used by government. To achieve these objectives, the Act has been based on these four general principles: that the public should have access to information held by government and its agencies, that exemptions from the right of access should be specific and limited, that decisions on disclosure should be reviewed independently of government, and that individuals have a right to privacy with respect to their personal information held by government institutions, and they should have the right of access to that information. Sounds pretty straightforward, doesn't it? Well, it is. And, oh yes, there is one other important point that needs to be made. Have a look at this.
Officials at the LCBO were made aware of the problem.
The Act also places a duty on the heads of government ministries and agencies to disclose a record which reveals a grave environmental, health, or safety hazard when it is in the public interest.
And yet the product was not withdrawn and no public announcement was made of it.
So there you have it, the essential ingredients of the new Act. A what? Oh, how does it work? Glad you asked. Well, to begin with, employees of Ontario government ministries and designated agencies have a vital role to play in achieving the objectives of the Act and efficiently delivering the required services to the public. But, and this is a very important but, the Act is not intended to raise any barriers, to create any impediments to the way things were done before. It has always been the task of certain provincial employees at all levels, in all ministries and agencies, to respond quickly and efficiently to the thousands of formal and informal requests for information that is made by the public every working day, and that will continue. The rule of thumb is this: with the exception of personal information, provincial employees are still free to provide all the information given out before the Act, and there's no reason to change now. The point is, the Freedom of Information legislation is designed to make more, not less, information available to the public and to individuals, with certain clearly defined safeguards built in. Okay, so now you know that under the Act, every individual has the right to see virtually all personal information held or collected by government in their name. There are some specific exemptions, of course, but in general, individuals not only have the right to see personal information, they have the right to request changes or corrections as well. To access information covered by the Act, a written request to the correct ministry or agency is all that is necessary. Enough detail must be included to allow for quick identification of the requested record. But because most people aren't that familiar with government, there's bound to be some confusion about where to go and what to ask for.
If you want, I can forward it to the proper office.
When that happens, employees and staff of ministries and agencies are required by the Act to provide all the help necessary to identify the record and speed the request to its proper destination. On-site assistance will be immediately available from ministry or agency-based Freedom of Information coordinators. If that means the request must be forwarded to a different ministry or agency, then so be it. And it's important to know there are also time limits for responding to requests, even when the request must be sent to another institution for handling. Generally, a request must be answered in 30 days, or the person making the request must be told why by the institution dealing with the request. Sure, the Act contains time limits, but really, when you think about it, it just makes good sense to respond rapidly to a request. After all, good customer service is important too. Most personal and other government information should be readily and rapidly accessible under the provisions of the Act. But there are some exceptions. Certain cabinet records, law enforcement matters, third-party information, and items required to protect personal privacy, among others. But even in instances where the exemption rule comes into effect, the onus is on government to comply with the request as much as possible by removing only the exempt portions and providing all the remaining record to the requester. As well, personal information may be stored in coded form. So, according to the Act, it's also the responsibility of government to provide the information in a form that can be easily understood. What's the matter? I see. What happens if your request has been denied because of an exemption and you don't think it's fair? Well, the Act also contains a clearly defined appeals procedure that includes recourse to an independently appointed Information and Privacy Commissioner who will rule according to the spirit and intent of the Act, which is to make available the greatest amount of information while protecting personal privacy. Yes? Oh, what about your privacy? How can you be sure it'll be maintained? Well, the Act takes an extraordinarily strong stand here, too, so you can be assured the privacy of your personal information will be protected. For starters, the Act restricts how personal information can be collected. In most cases, that means it can only be collected from an individual directly, and only by those who are authorized to collect it. Then, there are the very strict restrictions on how personal information is used and disclosed. Generally, the information may be used only for the purpose for which it was collected, and not used or disclosed for any other reason. It must be kept accurate and up to date, and its security must be assured at all times. Of course, with some exceptions, each individual has the right of access and to request correction to personal records, as well as the right to independent review by the Information and Privacy Commissioner. To help all Ontario residents know how and where to look for government information, directories like these are available in most libraries and government offices across the province. And to make the task of providing that information easy and efficient, the employees and staff of Ontario's ministries and agencies also have directories, as well as a comprehensive manual, training programs, and ministry agency-based Freedom of Information coordinators to support their efforts. In fact, the Freedom of Information coordinators are actually there to manage the whole process of responding to requests, to make recommendations on requests, and generally ensure everything works as smoothly as possible. Well, what do you think of Ontario's new Freedom of Information and Protection of Individual Privacy Act now? Ah, that's good.
Be seeing ya.
Ontario's Freedom of Information and Protection of Individual Privacy Act. It's good for all of us. Open government and the protection of personal privacy. This is the twofold purpose of the Freedom of Information and Protection of Individual Privacy Act. Several important areas of freedom of information and privacy protection are outlined in this module and will be dealt with in greater detail later in our videotape. Right now, we are going to discuss some basic definitions, general records which are available to assist the public, two directories which are available to assist the public, a manual for staff of institutions, and the important role which Freedom of Information coordinators play in the administration of the Act. Subject to certain specific exemptions to be examined in another module, every person has a legal right of access to records of a government institution. By institution, we mean a ministry of the Government of Ontario and any agency, board, commission, corporation, or other body designated in the regulations. Additionally, 3 years after the Act is in force, Ontario municipalities and their local boards will be covered by the legislation. The head of the institution makes decisions on access to information. In that institution, the head may delegate this authority in writing. And decisions can be appealed to the Information and Privacy Commissioner, who is independent of government. A record is any information, regardless of physical form or characteristics. Even in instances where one of the exemptions apply, the government must provide as much of the information requested as possible. This is achieved by severing a record, which means removing the information that is exempt and then disclosing the rest. When information has been severed, the requester must be told which section of the Act was used as the basis for refusing access. Similarly, the requester must be informed of the reason whenever an access request is refused. The Act also specifies that every individual has a right of access to his or her personal information contained in a personal information bank or in any other record. Some terms occur frequently. Personal information is recorded information about an individual who can be identified from the information. Personal information is usually located in a personal information bank, which is organized information capable of being retrieved. Specific types of personal information defined by the Act are discussed in Module 3, including income, financial information, medical information, and employment history. To satisfy a request for information, staff of an institution need enough information about the record to enable them to retrieve it, so the requester should provide as much information as possible. And to help the public in locating information, the Ontario government has compiled lists of its personal information and general records, which are published in the Directory of Personal Information Banks and the Directory of General Records. Both directories are available in institution reading rooms, the government bookstore, and most public libraries. Each institution under the Act has designated a Freedom of Information coordinator. While specific duties vary from institution to institution, his or her job is generally to coordinate activities in relation to the Act. One important and ongoing role coordinators play is training and providing information to staff. A staff manual which explains the Act and gives many examples is available to help coordinators and staff. The directories and other information contained in all ministry and agency reading rooms or libraries can also assist you in handling inquiries or requests under the Act. Dealing with the public requires good public relations at all times, and the Freedom of Information and Privacy Act requires strong customer services. In some cases, the coordinator will act as a focus or clearinghouse for requests for information. In other more decentralized situations, the coordinator may still be responsible to senior management and the head for the institution's overall administration of the Act. Procedures for dealing with requests in the various institutions vary as well. But don't worry, you'll get as much help and training as you need to handle your role in the process. Don't hesitate to ask your coordinator questions and examine the various manuals and directories produced to help you. Together, we'll make the Freedom of Information and Protection of Privacy legislation work. Open access to government is a major goal of the Freedom of Information and Protection of Individual Privacy Act. Consistent with this philosophy, the Act stipulates that necessary exemptions from the right of access should be limited and specific. This means that a narrow interpretation will be given to each exemption provision, and the institution will bear the burden of proving that an exemption is justified in the event the decision is appealed. The exemptions are detailed, and only the principles are discussed here. It is important to remember that the intent of the Act is to provide access to information. When access is refused, a specific reason must be given. There are 11 areas of exemption: cabinet records, advice to government, law enforcement, relations with other governments, defense, third-party information, economic interests of Ontario, solicitor-client privilege, danger to health and safety, personal privacy, and information soon to be published. Before we take a brief look at the various exemptions, you'll notice that most of these exemptions are discretionary. They begin with the words, "A head may refuse." This means that even if it is permitted to refuse, there is no obligation to refuse. For some exemptions, namely cabinet documents, third-party information, and personal privacy, refusal to disclose is mandatory. Now, the exemptions. First, cabinet records. The confidentiality of cabinet decision-making processes is a tradition of parliamentary government. The Act exempts from disclosure records that would reveal the substance of deliberations of cabinet. However, records more than 20 years old must be disclosed. Second, advice to government. This is a discretionary exemption only for records that would reveal the advice or recommendations of staff or consultants. The intent is to ensure that factual information used in decision-making should be accessible to the public. Third, law enforcement. This, too, is a discretionary exemption. A head may refuse to disclose a record where the disclosure could reasonably be expected to lead to certain results, such as interference with a law enforcement investigation, disclosure of confidential sources, and depriving a person of the right to a fair trial. Fourth, relations with other governments. A head may refuse to disclose a record that would interfere with the relations between governments or that would reveal information received in confidence from other governments. Fifth, defense. A head may not disclose any record that could prejudice the defense of Canada. Sixth, third-party information. Some of the information that institutions have on third-party enterprises is an asset to these enterprises, and its disclosure would impair their ability to compete. Disclosure of information of this type, supplied in confidence by a third party, could result in damage to their competitive position or in undue profit or loss. If so, the record shall not be disclosed. Seventh, economic and other interests of Ontario. A head may refuse to disclose information that could prejudice the economic or financial interests of the government. Eighth, solicitor-client privilege. A head may refuse to disclose a record that is subject to solicitor-client privilege. Ninth, danger to health or safety. A head may refuse to disclose a record where disclosure could be expected to seriously threaten the health or safety of an individual. 10th, personal privacy. Since one of the main purposes of the Act is to protect personal privacy, the instances in which personal information may be disclosed to other persons are very limited. In general, a head shall refuse to disclose personal information about one individual to another unless it falls under one of the specific provisions of the Act. These specific provisions are covered in some details in Module 3, but it is important to remember that the Act places a strong emphasis on the protection of personal privacy. Finally, information that is already or soon to be available in published form may be exempt, but the requester should be told where the information is available. This is good customer service. Even though the information may be exempt, the head may, in certain circumstances relating to the public interest, disclose the record. Each government institution has a designated Freedom of Information coordinator to answer your specific questions and help facilitate the working of the Act. He or she also has access to legal advice. While we've discussed exemptions in some detail, keep in mind that the spirit of the Act is to make information accessible. Providing access to government information while ensuring personal privacy. This is the balance the Freedom of Information and Protection of Individual Privacy Act seeks to achieve. While the Act gives every person a legal right of access to a record or part of a record in the custody or under the control of a government institution, it also denies access to personal information to anyone other than the person to whom it relates, with certain specific exemptions. Through its normal activities, government acquires substantial amounts of personal information. This includes national or ethnic origin, religion, marital or family status, education, medical, criminal, or employment history, identifying numbers, addresses, fingerprints, an individual's personal opinions, except where they relate to another individual, and opinions. Module 1 discussed the individual's right of access to their personal information and described the directory of personal information banks published to help public locate specific information. In addition, under the Act, every individual who is given access to personal information is entitled to request correction of the information, require that a statement of disagreement be attached if a requested correction is not made, and require that anyone who received the information within the year be notified of the correction or statement of disagreement. That seems clear, but what happens when someone else, a third party, wants access to personal information? Among the exemptions to the general right of access discussed in Module 2 is the very important one concerning personal privacy. The Act provides a basic rule that one individual's personal information must not be disclosed to another. There are, however, limited exceptions. These include the prior written consent or request of the individual, if the record is one to which he or she is entitled, compelling circumstances affecting the health and safety of an individual, personal information collected and maintained specifically as a public record, where other legislation allows disclosure, and where disclosure does not constitute an unjustified invasion of an individual's privacy. A disclosure of certain types of personal information to another individual is presumed to constitute an unjustified invasion of privacy. For example, medical, psychiatric, or psychological history, eligibility for social services, an individual's financial status, racial or ethnic origin, or religious beliefs. In deciding whether disclosure is not an unjustified invasion of privacy, examples of other factors to consider are whether the disclosure subjects the government and its agencies to public scrutiny, whether access may promote public health and safety, and whether disclosure may unfairly damage the reputation of any person referred to in the record. The Act also addresses the collection, retention, and use of personal information by institutions. As a general rule, personal information may be collected only from the individual, and the information shall not be used or disclosed except where the individual has consented to its use or disclosure, for the purpose for which it was obtained, or for a consistent purpose, or to an employee who needs the information in his or her job. And in a few other specific situations listed in the Act. You can see how much effort went into the Act to ensure a balance between access and protection, while at the same time preserving an institution's ability to function effectively and efficiently. The Freedom of Information Act simply demands that we treat all personal information as we would wish our own to be treated, with sensitivity and respect for privacy. Previous modules have discussed the philosophy and content of the new Freedom of Information Act. But how exactly will requests be handled? Each institution will apply its own procedures for handling requests, but the Act is specific on time limits, notification processes, preparation of and access to directories of both general records and personal information banks, tracking and reporting procedures. The material in this module is intended as an outline only and will be supplemented by training in procedures developed for your institution. Before we examine the Act in operation, remember this Act is intended to facilitate access to information, not to bog it down in red tape. If you gave out information before the Freedom of Information Act, you will continue to give out that information in the same way, with the exception of personal information. The first question to answer is, how will people know where to go to request particular information? In most cases, it will be clear to the person seeking information which institution will be likely to have it. In some cases, however, people will need help to find the appropriate institution. And the Act requires each institution to provide all the help necessary and speed the request to its proper destination. Available sources include the directories of general records and personal information banks, staff of the responsible minister, Freedom of Information coordinators. A request for access to information is in writing, and standard forms are available for these requests. Access to general records, access to personal information, correction to personal information. The Act is very specific on time limits. There is a 30-day time limit for processing a request if there is no extension. Remember, time periods are measured in calendar days from the day the request is received by the institution. If a request does not sufficiently describe the record, contact the requester and offer assistance. If there is a request for information that an institution does not have, determine where the information is. Forward the request to that institution within 15 days and notify the requester. Other times when the requester must be notified are when further information is needed, when a time limit has been extended, giving the reason, when a request affects another person, when severing is involved, giving the reason, when access is denied, giving the reason, when the estimated fee exceeds $25. As well, third parties affected by a request must be notified and given 20 days in which to make representations if they believe the information should not be disclosed. The requester is generally entitled to receive a copy of the record. In some cases, however, the nature or size of the record may make it impractical to reproduce. Then the requester will be given the opportunity to examine the original. Here is a summary of points which are common to all institutions. Time limits must be met. Requesters must be assisted in identifying the record. Requesters must be notified of decisions. Only one-time extension is allowed, and only in certain circumstances. But what happens when an individual is not pleased with the decision that has been made? One of the principles of the Freedom of Information Act is that decisions on the disclosure of government information should be reviewed independently of government. The Act provides